This is Celeste, and this is Wait, Is That Legal? A podcast that comes from my own curiosity about legal questions raised in TV shows and movies to determine what would or should have happened in the real world. So join me, a real lawyer, as I try to offer legal advice to fictional characters in fictional scenarios using real laws. This podcast is not intended to offer legal advice to real people in real legal situations. It is just for fun. Murder isn't always a crime is the tagline for the movie Double Jeopardy. This, admittedly, is catchy, but completely untrue. By definition, murder is a crime, the unlawful killing of another human being with malice aforethought, emphasis being on the unlawful part. The act of killing someone without determining any culpability or liability is a homicide. Death by homicide is often one of the explanations given by a coroner on the death certificate, as a way to explain the death as being caused by someone else. There are many ways that someone might die by homicide, but not be murdered. For example, a justifiable homicide, where the person does the killing in a justified manner and is allowed by law to do so, usually for self-defense or defense of others, or an accidental death that just happens to be caused by someone. So homicide isn't always a crime, but murder is always a crime. However, the movie itself is not even saying that murder is not a crime, just that the state can't put you on trial for murdering your husband twice. The movie frames this notion as being the protection against double jeopardy. Double jeopardy is a fundamental concept in the American justice system, but it is also fairly complicated in practice. Double jeopardy comes from the common law doctrines of autrefois acquis and autrefois convict, which translate to previously acquitted and previously convicted. The common law protections against being tried again for an offense the defendant was previously acquitted or convicted of are enshrined in the U.S. Constitution in the Fifth Amendment of the Bill of Rights. The relevant part of the Fifth Amendment states, quote, "Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb." End quote. The Fifth Amendment protection was extended to the states through the Due Process Clause of the 14th Amendment, although some states have their own state constitutional protection against double jeopardy. Double jeopardy functions as a procedural safeguard, preventing the government from trying someone for the same offense twice. So, on the surface, it would seem like Ashley Judd's ex-lawyer/inmate friend is correct when she tells Judd's character, Libby, that when she gets out of prison, she can go and kill her husband, and there is nothing anyone can do, because she was already convicted for his murder. Unfortunately, that is a complete misinterpretation of what double jeopardy means. Thankfully, it does not seem like anyone has tried to take that inmate's advice in real life, because there doesn't seem to be anything in the research where someone tried to use Double Jeopardy, the movie, as a defense. Which, considering the circumstances in the movie, is not that surprising, because it is a pretty unlikely scenario. In the movie, Libby's husband frames her for his murder. He takes her out on a borrowed sailboat and in the middle of the night stages a murder scene, where Libby apparently uses a kitchen knife to stab him, and he radios for help, then falls overboard into the ocean. There is a lot wrong here, but because there's no body and the Coast Guard finds Libby on deck, covered in blood and holding a knife, they do the logical law enforcement thing where they don't investigate, they just assume that she must have done it. To be fair, they do wait a while to arrest her as they try to find the body. There are a lot of things that don't really add up, but I imagine that if this were a real case, HBO or Netflix would have made an excellent true crime documentary about the case, And some intrepid podcaster, internet sleuth, or true crime author would have tracked down Jonathan Devereaux because he wasn't doing a great job of hiding out in New Orleans. But we are not litigating a fictional investigation here, and honestly, people have been convicted of murder on far less evidence. So Libby is convicted for the murder of her husband, whose body is never found because the ocean. And she serves 6 years in the least secure high security prison I have ever seen. I mean, at least 2 of the women that Libby bunks near are also convicted murderers, so serious felonies. And yet there doesn't seem to be any cells, just 20 or more bunk beds lined up in one large room, like a massive military boot camp scene. And the idea that some of these women are serving life sentences for murder and are just sleeping in the open with several dozen other prisoners is actually a nightmare. Sorry, just needed to get that insanity out there. So after 6 years of her murder sentence, Libby is paroled. Yeah, she serves 6 years. She is sent to a halfway house that is supervised by the former lawyer, now parole officer, Tommy Lee Jones. There are a lot of ex-attorneys in this movie, and yet none of them seem to understand what double jeopardy is, which is probably why they're ex-lawyers. All Libby has to do now is keep out of trouble for 3 years. But she doesn't do that, because she has a husband and a son to track down. And after only a couple of stops along the way, Libby tracks down her husband in New Orleans, where he is going by the name Jonathan Devereaux, and is the owner of a fancy hotel and the apparent center of the high society New Orleans social scene. Libby confronts him in order to find her son, and he tries to kill her. Tommy Lee Jones realizes that Libby is not lying about being innocent, and the two of them confront the husband for the final time, which results in the husband being killed. For real this time. So because Libby is the one to kill him, but she has already been convicted of his murder, can she be convicted of murdering him a second time? The short answer is yes, she could absolutely be charged with murder a second time. The long answer involves digging into some Supreme Court cases. We have the language of the Fifth Amendment, again, quote, "Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb," end quote. But we also need the long history of Supreme Court precedent to fully understand how and when double jeopardy comes into play. The plain language of the amendment is clear that you cannot be tried for the same crime twice by the same authority. If you are found not guilty of committing murder in the state of Washington, Washington cannot try you for the same murder again. That would very clearly put you in double jeopardy and would violate your constitutional rights. In order to determine whether the defendant is being punished twice for the same offense, the court uses the Blockburger test from the 1932 case Blockburger versus U.S. The test is, quote, "Where the same act or transaction constitutes a violation of two distinct statutory provisions, the test to be applied to determine whether there are two offenses or only one is whether each provision requires proof of an additional fact which the other does not." End quote. To illustrate this, we can look at the facts of the Blockburger case, where the defendant was charged with multiple counts under the Narcotics Act, but argued that the multiple charges were all the same offense, so he should only be charged with one crime. Blockburger tried to argue that because he was selling drugs to the same people, or on the same day, or in the same package, the state put him in double jeopardy when they charged him with separate crimes for each transaction. This is, of course, ridiculous, but you have to try, right? The court also thought that this was a ludicrous argument, stating, quote, "The test is whether the individual acts are prohibited, or the course of the action which they constitute," end quote. The Narcotic Act prohibits each individual sale, not the entire enterprise of the drug dealing operation. Selling drugs is inherently transactional, so each sale is a separate violation of the statute because separate facts make up each of the counts. Transactions that took place on the same day were at separate times or in separate locations with different buyers or involved different amounts or kinds of drugs. Due to the differing facts, double jeopardy did not apply. This is in contrast with several older cases from the 1880s, dealing with a Utah Territory statute that aimed to punish polygamy. One of these cases, in re Nielsen, involved a defendant criminally charged under two subsequent amendments to a Utah statute. The amendment passed in 1882 prohibited the cohabitation of any male with more than one female, and it was punishable as a misdemeanor. The 1887 amendment raised the punishment to a felony and elevated the crime of unlawful cohabitation to adultery. Nielsen was charged under both versions of the statute. He had initially pled guilty to unlawful cohabitation, but then later was charged with adultery. The Supreme Court agreed with Nielsen that the second charge put him in double jeopardy because unlawful cohabitation had similar elements of the felony offense of adultery. Utah tried to argue that they charged Nielsen with adultery for the act of living with the second unrecognized wife from 1887 up to his arrest. The court disagreed with this tactic because the cohabitation was continuous and the behavior remained the same pre-1887 and post-1887. Nielsen was already punished for cohabitating with both women for the entire time. So by charging him with adultery for the same act he already paid for, he was put in jeopardy for the same offense twice. The entire timeline of the prohibited cohabitation involved the same facts. Nielsen living in the same house with two different women, but they were the same women, so there could only be one offense committed. Further explanation of the Blockburger test is illustrated in the 1977 Supreme Court case Brown v. Ohio, where the defendant is charged by the state of Ohio and convicted of joyriding. Then, after serving his sentence, is charged again with car theft, still in Ohio. This was held to be a violation of the defendant's Fifth Amendment rights, because joyriding is included in the statutory definition of car theft, and double jeopardy still applies even if the defendant is convicted. As the court puts it, quote, the double jeopardy clause protects against a second prosecution for the same offense after acquittal. It protects against a second prosecution for the same offense after conviction, and it protects against multiple punishments for the same offense. End quote. In Ohio, the crime of car theft was defined as joyriding with intent to deprive the owner. Because joyriding is an explicit element of the crime of car theft, it is considered a lesser included offense. The court notes that lesser included offenses have long been considered as part of double jeopardy, stating that since 1889, quote, where a person has been tried and convicted for a crime which has various incidents included in it, he cannot be a second time tried for one of those incidents without being twice put in jeopardy for the same offense. End quote. Using the Blockburger test, we can see that a lesser included offense like joyriding is going to contain the same elements and facts as the greater offense. So the lesser and greater offenses cannot be considered two separate offenses. The issues brought up in Brown, Nielsen, and Blockburger illustrate why prosecutors often charge defendants with a list of crimes that are essentially the same but have varying degrees of culpability. If a state wants to make sure someone is found guilty of killing someone, They will charge them with murder and the lesser included offenses, like manslaughter, which will give the jury more discretion in convicting someone, but also avoids the issue of double jeopardy. So you might be thinking that in any situation where someone is charged with a crime and is either convicted or acquitted, then they can never be charged for that crime ever again, right? Well, that's not true. This was learned the hard way by the defendant in Heath versus Alabama, a case from 1985. Heath hired two men to kill his pregnant wife. The men kidnapped the wife and murdered her, leaving her body in Georgia. Heath was later charged with her murder by the state of Georgia and decided to take a deal to avoid the death penalty by pleading guilty. Then Alabama decided to charge Heath with murder. How? Well, Heath lived in Alabama, and Heath's wife was kidnapped from their home in Alabama. So the state of Alabama determined that they also had jurisdiction over the murder. And to further complicate things for Heath, Alabama also had the death penalty, and they weren't offering Heath a deal. And they had no reason to. He had already confessed to murder in the deal in Georgia. So the case made it to the Supreme Court, with Heath arguing that he had already been convicted of murder in Georgia. So Alabama was putting him in jeopardy by charging him for his wife's murder a second time. The court disagreed. They cited precedent from as far back as 1852 of the dual sovereignty principle, stating, quote, "An offense, in its legal signification, means the transgression of a law. Consequently, when the same act transgresses the laws of two sovereigns, it cannot be truly averred that the offender has been twice punished for the same offense, but only that by one act he has committed two offenses, for each of which he is justly punishable." End quote. So, despite being charged for murder in both states, he is not being held to account for only one offense of murder, instead being charged for murder under Georgia state laws and then again under Alabama's state laws. The dual sovereignty principle applies anytime there are two or more legal entities that draw their legal authority from separate sources of power. Ever since the foundational Supreme Court decision in McCulloch v. Maryland in 1819, the court has recognized the separate legal authority of the federal government and the individual states, as well as the distinct sovereignty of each of the states in relation to each other. Each state's authority to make and enforce its own laws goes back to the sovereignty of the original 13 colonies held prior to joining the Union, and is preserved in the 10th Amendment. As such, each state has its own constitution and the ability to create and enforce its laws. The federal government also exercises its own legal authority, which comes from the U.S. Constitution. As the court puts it in McCulloch v. Maryland, quote, "In America, the powers of sovereignty are divided between the government of the Union and those of the states. They are each sovereign with respect to the object committed to it, and neither sovereign with respect to the object committed to the other." End quote. This is probably most obvious when it comes to murder. All 50 states have their own laws against murder. The federal government also has a murder statute. However, murder is only prosecuted in federal court by the U.S. Attorney's Office when there is federal jurisdiction. There has to be a connection to federal law in order for the federal government to step in. So, usually, a murder involving a federal employee taking place on federal land or involving an institution that is federally insured, like a bank, or federally regulated, like an airport. This is why O.J. Simpson was never retried in federal court. Only the state of California had jurisdiction over the case. So, for double jeopardy purposes, any sovereignty with its own legal authority that has jurisdiction over the case can bring that case, and it will be considered a separate legal offense for each of those sovereigns. In contrast, there are times where dual sovereignty does not apply, such as in Nielsen versus Oregon. This is a different Nielsen. A 1909 case where the state of Oregon tried to fine a fisherman for fishing without a license in the Columbia River, despite him having a fishing license issued from the state of Washington. In that case, the court stated that the dual sovereignty principle could not apply because the Columbia River creates a shared boundary between the two states, giving them concurrent jurisdiction. When there is shared jurisdiction, then regulated activities that are licensed by one state cannot then be prosecuted by the other state. But we're not going to explore that question any further in this episode. I just thought it was an interesting argument that was brought up in the Heath decision. So, unfortunately, or fortunately, depending on how you feel about these things, Heath was subject to the jurisdiction of Alabama as a resident of the state and as the location of the abduction and the conspiracy, and the jurisdiction of Georgia as the place where the murder occurred and the body was dumped. He would probably also have been subject to federal jurisdiction due to the kidnapping occurring over state lines, but the federal government seems to have declined to get involved, likely because there was adequate action taken to prosecute the crime, and Heath was at the very least going to be spending time in jail in Georgia. Now that we have a better understanding of double jeopardy, we can look at how it might apply in Libby's case. Obviously, Libby's situation is highly unusual in that her husband is legally dead. But leaving that wrinkle aside, would Libby be able to claim double jeopardy for the second murder of her husband? If Libby was already charged, tried, and convicted of murder, served her time, and was released, would charging her again put her twice in jeopardy for the same offense? By definition, murder is a one-time per person offense. So if we're just talking about one jurisdiction, you can technically only kill a specific individual once, and each individual killed is its own separate charge of murder. All lesser included offenses of murder are also specific to one individual. Theoretically, it would be impossible to kill someone twice. Either the first time is an attempted murder, or the second is mutilation of a corpse. Murder is not an ongoing enterprise. It is assault, battery, or attempted murder, right up to the point that the victim is dead. Due to the one crucial fact that her husband was still alive, Libby was wrongfully convicted of murder. This is unfortunate, and she might have legal remedies she could pursue, but it's not a free pass to commit the crime that you were falsely convicted of. At the very most, she could only have been guilty of attempted murder. And in Washington state, criminal attempt to commit first or second degree murder is a Class A felony, which carries a maximum penalty of life in prison. So the fact that Libby only served 6 years is pretty good for attempted murder or murder. The crimes of conspiracy and attempt are often classified as separate offenses for the purposes of double jeopardy, despite technically being lesser included offenses of the greater crime. Conspiracy is the agreement to commit a crime with an overt act made in furtherance of committing the crime. Conspiracy is not usually charged once the crime is committed. However, the Supreme Court considers conspiracy a separate crime under the Blockburger test, because to commit conspiracy, there is an agreement between co-conspirators to commit the crime, and this is a fact that is unique to conspiracy and not required for the underlying crime. For example, say Adam, Buddy, and Charlie agree to rob a bank. Adam steals the getaway car, Betty makes the masks, and Charlie gets caught lurking around the bank after hours. Each has acted in furtherance of the conspiracy to rob the bank, but they fell short of actually robbing the bank. But if Charlie did not get caught and they did rob the bank, then the conspiracy would be complete, and then each of them would be guilty of robbery. The elements of conspiracy to commit a robbery are an unlawful agreement between two or more people to commit the robbery, and an overt act in furtherance of the conspiracy. The elements of the crime of robbery are a trespassory taking and carrying away of another's property with the intent to deprive the owner permanently, and the taking is from the person or presence of the owner by violence or intimidation. The two crimes contain separate elements that would require different facts to prove, so they are separate crimes under double jeopardy. Criminal attempt is to act with the intent to commit a crime that falls short of the completed crime. Attempt usually merges into the greater crime once that crime is complete, and therefore attempt is almost always a lesser included offense of the greater crime that you are attempting to commit. Criminal attempt to commit murder is an exception to the rule. Murder is the unlawful killing of another person with malice aforethought. And attempted murder is the specific intent to commit murder with a substantial step taken towards committing the murder, but the murder is not complete. So normally, an attempt to commit a crime and the crime itself merge once the crime is complete. So they are not considered separate offenses because all the facts to prove attempt are used to prove the greater crime too. Murder is unique because in attempting to commit murder, you have failed to fulfill the most important element of murder, mainly the unlawful killing of another. The lesser included offenses of murder, like manslaughter, all require that the victim is dead. All that changes is the level of culpability in causing that death. Once the victim dies, attempt to commit murder merges into the crime of murder. Murder does not have a statute of limitation and is pretty specific as to the intent of the action, but the result could actually take some time. Other crimes have statutes of limitations, which is the window of time where the state can charge someone with committing the crime. This makes it highly unlikely that someone could be charged with the attempted crime and then that the crime is completed after with enough time to be charged again. Or that it would even be possible for the crime to be attempted and then completed after some time at all, without it being two separate offenses. But with murder, it is possible to attempt to kill someone and then they don't die until years later, but it can still be tied to the attempt. For example, in a situation where a victim is shot but survives the gunshot wound, the defendant could be found guilty of attempted murder. Then, while serving their sentence, the victim dies, and it is determined that it was a direct result of the gunshot. It was just delayed over several years. This is called the delayed death exception. Prosecutors could decide to charge the defendant with murder based on the fact that the victim is now dead. These are two offenses that stem from the same criminal behavior and are not subject to double jeopardy. This is all theoretical, though, because there are no Supreme Court cases where someone was charged with attempted murder, served their time, and then the person died from their injuries and the person was tried again for murder. There have been cases where prosecutors thought about bringing murder charges but couldn't for other reasons, or chose not to because of a remoteness between the attempt and the death. For example, prosecutors considered retrying John Hinckley Jr. in 2014. Hinckley had attempted to assassinate then President Ronald Reagan in 1981. but managed to injure a bunch of people in the process. And one of those people that was injured was the serving White House press secretary of the time, James Brady. Brady was severely injured and continued to experience complications as a result of the gunshot wound delivered by John Hinckley Jr. And he continued to experience these complications all the way up till his death in 2014. Brady's death was ruled a homicide and could be directly linked to the gunshot wound. But ultimately, the prosecutors decided not to try Hinckley with murder after he was previously found not guilty by reason of insanity of the attempt charge, because they figured that all of the same facts would be in place to find him not guilty by reason of insanity for murder as well. But it's unclear whether this would be a violation of double jeopardy or not. There is also the case of Benjamin Dowling, who was shaken as a baby by his former babysitter, Terry McCurchie, in 1984. He died at the age of 35 in 2019, and in 2021, prosecutors in Florida announced that they were charging McCurchie with murder. McCurchie had pleaded no contest to the attempted murder and to aggravated battery in 1985, and served 60 days in jail and 3 years probation. Dowling's death was linked to the injuries that he sustained in 1984. McCurchie has not fought extradition from Texas and maintains her innocence, and I couldn't find anything more recent in this case, so I assume that it is still pending. The articles I found that discussed this case talked about double jeopardy not being a factor because of the delayed death exception. So it'll be interesting if it does actually happen. There have been cases where the defendant was still serving the initial attempt sentence, and then the murder charge was admitted to and added on to the sentence, usually because the person was already serving a life sentence. But it would be incredibly difficult to either prove a defendant's innocence in the murder case after they were convicted of attempted murder, or to prove a defendant's guilt after they were acquitted in the initial attempt charges. And also, some states actually limit the amount of time that can pass between the attempt and the victim dying from the attempt. So in California, in order to be charged with murder, the victim has to die within 3 years and a day of the initial act. At common law, the rule was usually a year and a day, because forensic science and determination of cause of death were not as sophisticated as they are today. In Libby's case, the false murder conviction and possible second murder charge would be separate offenses. The first murder took place in Washington and was a stabbing and/or drowning death. The second murder took place 6+ years later and happened in Louisiana and was a gunshot death. The only thing that ties these two crimes together is that the defendant and the victim are the same. So in this scenario, Libby's actions are even worse than the delayed murder charge I mentioned before. This is not a murder that happened years afterwards as a result of the initial attempt to commit murder. This is an entirely new crime, completely unrelated to the previous attempt. If a delayed murder charge isn't subject to double jeopardy, then a second go at finishing off the victim is definitely not subject to double jeopardy. The other important fact is that the two murders take place in separate jurisdictions. So if they were somehow considered the same offense, the dual sovereignties principle would apply. Washington tried Libby for murder under their laws, and Louisiana is going to want to try her under their own murder statute. So regardless of how you look at it, Libby cannot claim that Louisiana charging her for murder would somehow violate her constitutional rights against double jeopardy. In the end, to be completely honest, I really don't think that Libby would actually be tried with the second murder. The facts are just too outrageous, and public outcry would likely be enough to prevent Louisiana from charging her with murder, and probably Washington would overlook her parole violation and additional crime and just give her time served because she didn't actually kill her husband the first time. The fact that the second murder was also in self-defense and defense of others would be a factor as well. It was probably a justifiable homicide, and likely Louisiana would just be happy to not have to deal with the whole legally dead but now really dead pattern. It seems that this is how it plays out in the movie too, because Libby is able to just leave the scene and go find her son. And there's no mention of further legal complications. But just because the facts play out in Libby's favor in Double Jeopardy does not mean it is sound legal advice. Double jeopardy is a procedural protection that is never going to be a free pass to commit a crime a second time, even if the first time it was a wrongful conviction. Thank you for listening. This show is researched, written, and recorded by me, Céleste. None of the legal advice or opinions expressed in this episode are intended as specific or individualized legal advice. Please like, subscribe, rate, or review this podcast if you enjoyed it. If you have any questions or comments, please email them to waitishatlegal@gmail.com. You can find the podcast on Twitter, Facebook, and Instagram. Don't take legal advice from disbarred jailhouse attorneys, and don't go sailing alone with your husband after he has taken out a huge life insurance policy.